and another, Respondents, and Secretary of State for Work and Pensions, Appellant.
Lord Lloyd-Jones will explain the decision of the Court.
The respondents, Ms. Fratila and Mr. Tannhauser, are both Romanian nationals residing in the United Kingdom. They each made applications for universal credit in June of 2019. At the time of their applications, the respondents' right to reside in the United Kingdom arose solely from their pre-settled status under the EU settlement scheme. Respondents' applications were refused because the relevant social security regulations, to which I will refer as the 2019 regulations, do not permit universal credit to be granted solely on the basis of an individual's pre-settled status. Respondents challenged the refusals of their applications for universal credit by way of judicial review. They argued that the 2019 regulation should be quashed as contrary to the prohibition on discrimination on the grounds of nationality in Article 18 of the Treaty on the Functioning of the European Union. The Court of Appeal agreed with the respondents by a majority, Lord Justice Dingerman's dissenting, that the 2019 regulations are contrary to Article 18. The Secretary of State for Work and Pensions now appeals to the Supreme Court. The Supreme Court unanimously allows the Secretary of State's appeal. Because this appeal is concerned with EU law as it applied while the United Kingdom was an EU member state and during the transition period which followed, decisions of the Court of Justice of the European Union are binding on the Supreme Court. On the 15th of July 2021, the Court of Justice handed down its judgment in CG against the Department for Communities in Northern Ireland, a reference made to the Court of Justice by a tribunal in Northern Ireland. That case concerned certain regulations governing universal credit in Northern Ireland. The Court of Justice held that Article 18 of the Treaty on the Functioning of the European Union had no application to those Northern Irish regulations, which are materially indistinguishable from the 2019 regulations at issue in this appeal. Following the Court of Justice's decision in CG, the respondents are therefore unable to rely on Article 18 in their challenge to the 2019 regulations. Shortly after the Court of Justice handed down its judgment in CG, the respondents sought to advance a new case based on the EU Charter of Fundamental Rights. It would be inappropriate to permit this case to be raised at this stage in the proceedings because it concerns issues of fact which have not been determined. The Secretary of State's appeal is therefore allowed, and the respondents' challenge to the 2019 regulations fails.
The Court will now adjourn.